Berman, the trustee.
Tom Lester, counsel for the debtors.
Let's take the exemption objection first.
And I guess, Your Honor, may we take whether or not the settlement should be approved first, because I believe that...
Oh, I could take that, yeah,
because that would make everything else...
That's one argument on the sale motion, right? The settlement motion isn't really on for here.
No, that's the only one that's actually on for today.
Oh,
Well,
it
they're both
is.
on.
Yeah, but the settlement motion is the only one that's actually been continued appropriately till today, and then we had these other pleadings come in. So the settlement was thrust, that's what was set, and then there was additional pleadings, so we moved everything over till
All right,
today.
maybe I'm misunderstanding what you're calling the settlement, though. So originally there was going to be a settlement with, if I can call her that, the Washington Heidi Powell, correct? And then you got an overbid, essentially, from the Arizona Heidi Powell. And so it was continued to today, but was it continued today for consideration of then the sale? Has it morphed into a sale motion? Is that what's on to me? Or are we arguing about whether you get to withdraw the settlement motion?
Well, let me just add to what you said, is that originally the Arizona Heidi Powell had offered $10,000, and we had a hearing on that, and at that point in time, Your Honor gave some case law to the two of us and sort of implied, at least in my opinion, that perhaps I might want to reconsider because it might not be worth it given the time and expense involved and only a $10,000 offer. So at that point in time, I withdrew that offer, or I withdrew my motion to sell, and then I thought about it, did some research, discussed it with counsel, and then brought this motion to essentially sell to the debtors for essentially $10,000, but it results in their paying the non-exempt amount. And then in the meantime, the Arizona Heidi Powell has now offered $20,000. And so, one, I've made clear in my submissions to the court that that's pending. I've indicated my position that, based on my prior experience with the court, that in the past I haven't, when that's happened, usually, of course, with like pending real property sales, I haven't been required to do a new motion or give new notice to the extent that notice has gone out to creditors and they haven't objected to a smaller amount. The court has then just gone ahead and decided whether or not to accept the higher amount, and given that to do a new motion would just delay the matter even further, which I assumed that counsel did not want further delay. Essentially my position is that we're here to decide whether or not to as counsel wants you to do, to go with the agreement that we had at one point in time to have the debtors pay me some money, or for you to decide that it's in the best interest of the creditors to accept the $20,000 offer.
Okay, I will consider argument on the 9019 motion. It's confirmed for argument. I will also consider whatever arguments you have as to why I shouldn't be considering the, in essence, overbid by Arizona Heidi Powell. But I think neither of you really, well, your opposition, which frankly I very much appreciated the good briefing here. It was very gratifying to see really good briefs from both sides. So I compliment you both on that. I don't often in matters of this size get such sophisticated briefings, so that was great. But neither of you really argued about well, Mr. Berman argued that there's plenty of good due process. Any creditors seeing the notice, was that a full matrix mailing?
Yes.
On the settlement?
Yes.
Anybody that didn't object to his first proposal would have not been hurt due process-wise in not opposing the as it evolved request for sale, even though it's certainly not a settlement at this point, it's a sale request. But that, in essence, I take the argument as being anybody would have read your pleadings for the first settlement as also being, in essence, a sale, and that this is no different than simply an overbid on a proposed sale, that if the terms weren't worse and nobody objected, or only one party objected, then you don't need to renotice it out when you got a better offer. Is that's
yes,
your
that's
argument?
my argument, and also the fact that that's what's happened before in other similar circumstances where the court has not required anything else.
Right. Well, but in those circumstances, I would want argument on, well, were the pleadings sufficiently clear that that first settlement was in essence a sale, putting it in play, that if they didn't think that price was adequate, that they would have, that the same potential parties in interest would have objected.
Right. We had an original motion to sell for $10,000 to the Arizona Heidi House.
And nobody objected to that except the debtor.
Correct.
Then you had a subsequent motion, but that's really what's on for today, is a subsequent motion to approve a settlement, but that motion itself was clear enough that it was a sale, correct? That's your
Yes.
In
argument?
my opinion.
Yes, it was, yeah.
Okay, all right, so I don't have I don't have a dispute on that.
You
All right,
don't-
so I'll hear it, and if you want to bifurcate it and have me hear the estoppel argument, if you want to call it that, on the 9019, I'll hear that, but then I think it's logical to turn to the exemption argument, and then I'll turn to the rest of the argument. All right, so we'll split it up that way, even though it's cutting that motion in half and and putting the exemption motion in between.
And Your Honor, I guess the reason that I'm asking for the argument to be kind of cut into sections is I don't believe that the court needs to go any further than the argument.
I get your logic. So,
And
okay,
procedurally, the court hit most of the high points, but not all of them.
all right, but it is Mr. Berman's motion, so
Actually,
I
no.
will hear from you on this forced 9019 argument first.
The accord and satisfaction.
Yes.
Well, essentially, I mean, my approach is that it's not, first of all, in any event, even if the argument is a valid argument, that the court always has the ability in the best interest of the creditors to decide for itself what is in the best interest of the creditors. So even if the trustee would be bound, that the court can nevertheless decide to do something differently. And that would be what I would be suggesting, of course. But my approach has always been that every time I talk to someone, it's subject to approval of the court. And so to the extent that it's subject to the approval of the court, if something comes up that changes things, that makes it no longer in the best interest of the creditors, then it seems to me it's my duty to try to get the best that I can for creditors. I guess ultimately, if I take it to the logical conclusion, I could just simply say, I'm not going to submit it to the court, and therefore it's not going to be approved, and therefore you're not going to get your results. So I don't know that it necessarily applies in the situation for bankruptcy trustees, given the unique situation that we're in. But even if it does, you can do whatever you want that you think is more appropriate.
And Your Honor, I don't fundamentally disagree with the trustee's concept that you can do whatever you think is appropriate, because I understand that any settlement must pass the court's review. However, what I wanted to do, especially with the procedural setting of this particular matter, give the court the option of accepting the settlement. Because what we have here is, even at $20,000, or probably even at $100,000, the necessary litigation to sort out whether a domain name is property for bankruptcy purposes in Washington is going to be an extensive, difficult process. I also believe that when you look at, and we'll get to these later, but the exemption issue and the property issue, I think the debtor prevails. However, we've also got a larger issue for administration of the courts. And that larger issue is, as debtor's counsel, should I put any stock whatsoever in discussions with the trustee? Or should I realize that's just a temporary thing and I shouldn't plan on there being any follow-through besides the court looking at it? It changes the nature of what we can do, and it suggests that the trustee then really has no authority, and it makes it the difference between Rule 9019 and 363 non-existent. Yes, in a statute 363 situation, it's just a sale, and there's a bidding war, and absolutely the highest bid wins. In a Rule 9019 situation, it is the resolution of disputes, which, when you're looking at the administration of the court, that's what you want to have happen. You want people to step back, think about the relative positions, and come up with creative solutions, like we did here, like we implemented here, like we had all set ready to go, and was not objected to by anybody. I think Trustee Berman did exactly the right thing by informing the court that after the second continuance of this motion to accept, somebody said, I'll throw some more money in, but that doesn't change. The fundamental question is, was there some kind of a resolution so that the trustee and the debtor could move forward beyond this dispute? We assert there was. We assert that we did those necessary steps to implement that resolution. That was set for hearing. And in addition, and I don't know the court, there's no reason you could remember this, but when we had our first hearing where the trustee objected to our exemptions back in November, the court set a schedule for filing of pleadings if we were actually going to contest the issues, if we were going to contest whether the exemptions existed, if we were going to contest whether a domain name was property. Those schedules were set, and rather than having any pleadings suggesting that we were actually going to have a knockdown, drag-out fight about those issues, counsel and the trustee got together, we came up with a resolution, and what was set before the court was approval of that resolution. We got right up to the eve of that, and then the trustee continued, and now we find ourselves where we're back looking at all the different issues. But I am not in dispute that the court can do whatever it believes appropriate. I'm just requesting that the court take the tack available to it to approve the settlement, because this is not the case to have the issue regarding whether domain names are property determined, because it's going to go probably further and further. And that's why I brought the pleadings that I did, and that's why I wanted to focus on that.
All right, I understand.
I'd like to quickly respond.
Sure.
I'm not suggesting to the court that the trustee has absolute discretion to willy-nilly do anything that he or she wants. In this particular case, the court itself had indicated that $10,000, this case might not be sufficient for a lot of time and effort and litigation to be involved. When the additional $10,000 came in my mind, that changed the calculus that I was using. In fact, if the $20,000 is accepted by the court, and if the court also rejects the attempt to amend the schedules, then we would have a bankruptcy where all of the creditors will end up being paid in full.
All right, thank you. So the debtors argue in various ways that the trustees precluded from now accepting Arizona Heidi's offer because he has already reached an agreement with the debtors. This is incorrect, although I know you didn't say that starkly, Mr. Lester, but that general notion would be incorrect. A bankruptcy trustee is charged with maximizing value of the estate. Quote, if the trustee has information that an agreement the trustee has made is no longer advantageous to the estate, the trustee has a duty to advise the court of that information. In Ray Lane, 2006 Bankruptcy Lexus 3158 at 5, Bankruptcy District of Oregon, November 15th, 2006. In addition, quote, a trustee's fiduciary duty to maximize the assets of the estate trumps any contractual obligation that a trustee arguably may incur in the course of making an agreement that is not enforceable unless approved by the court. Everyone who deals with a bankruptcy trustee in a transaction that is not in the ordinary course of business is charged with knowledge that the law may require court approval and that a trustee has an obligation to present all relevant facts to the court, including whether there is a more attractive solution to that which the trustee has negotiated, close quote. In re Mickey Thompson Entertainment Group, 292 BR 415, 421, Bankruptcy Appellate Panel, Ninth Circuit Bankruptcy Appellate Panel 2003. I will mention the Mickey Thompson case comes up in my court occasionally when you have a blended settlement and sale. Blended settlements and sales aren't that unusual in bankruptcy court, and the Mickey Thompson case deals with the procedural niceties of that and basically says you have to follow both 363 and 9019 when you have one of those blended sales. For these reasons, I conclude the trustee is not bound by any settlement or other agreement he may have heretofore reached with the debtors, and I'm not addressing the rest of the issues at this point. I will also say, I mean, the good example of when a court might overcome an overbid, even if the trustee was supportive of that overbid, is where there's been a sale procedures order put in place and a very set procedure for sale of an asset's been put in place. A buyer is conformed with that, somebody else has not conformed with those procedures, and then wants to waltz into court at the last minute and make an overbid after all of that prior procedure has happened. Your argument partially goes a little along those lines in that there was some procedural history that was set up that then wasn't followed when the overbid came, but it isn't quite the same thing as a very strict sale procedures order. So I think in this case, I wouldn't be able to find in the face of that overbid that the settlement is in the best interest of the estate. Or that the sale aspect of it is either. So whether the trustee brought it to my attention or not, if those facts were revealed to me, I wouldn't have approved the settlement as long as the Arizona Heidi offer was still pending. All right, let's move on to the exemption question then. So it's the trustee's objection to exemption.
All right, I've got at least two arguments. One, that the attempted amended Schedule C is ineffective, as far as I can see, no copies of the amendment have been sent to creditors as I feel is required by Bankruptcy Rule 1009. It says the notice has to go out to any entity affected thereby. I read that as saying that that includes creditors, because obviously to the extent that there's a new amendment or an exemption or an increase in exemption, that would affect what the creditors could potentially get in the future. So I don't see that that's been done, so I don't see that just on that basis alone that the attempt to amend Schedule C is effective. Secondly, it's always been my position throughout the case that essentially I see the debtors as coming into the court with unclean hands, that to me is black letter law, that you have to list all your assets. They did not do that. We have a situation where, I mean, I've cited to the court, a few cases where, there were debtors in other cases that were denied discharges simply because they didn't disclose things that were only worth a couple $100. It seems to me to support my argument that you've got to list all your assets no matter whether you think that they have any value or not, because obviously the trustee, they have an entirely different idea and they think that they're worth something and therefore would do something if the trustee knew about them. We have a situation where in 2016 we had the Arizona Heidi Powell attempting to make contact with the debtors, not the debtors at that time, but the former debtors, indicating that she had an interest in purchasing from them the domain name that would have told them at that point in time that it had value, and they still did not amend their schedules. And in that same year, 2016, the Arizona Heidi Powell went so far as to hire an attorney and sued them in court over it. That just emphasized to a T that, the domain name must be really important for the Arizona person who had gone to all the trouble for that time and expense to try and get that domain name from them. So again, they did not do anything to amend their schedules to let the trustee know, to let me know that this was going on, that there was some value to it. So for those reasons, I think that they come in with unclean hands and they shouldn't be allowed to object. They shouldn't be allowed to amend their schedules at this late date. If they had listed the domain name in the very beginning, it may well have been the case where the Arizona Heidi Powell may not have known about it, and I wouldn't have probably been contacted by anyone, perhaps, and then it might not have been an issue, and the case would have closed, and the domain name would have been abandoned, and we could have all eliminated all this time and effort that we're spending now. If they just simply would have done what I think they should have done, were required to have done in the first place.
All right, Mr. Lester.
Your Honor, I think it's important not to look at the situation with the lens after December 15th, 2016. And I bring that up because of the schedules change. And as the court will note from the pleadings that have been filed in this matter, it's not settled in Washington what exactly we're talking about here. What is a domain name? It's not clear that it's property, and it definitely wasn't clear in 2012 whether it was property, nor was there a spot in the schedules that showed where to put it. In my pleadings, I noticed that in 2012 there were two different sections where it may have been if it was property, and I put that mays in there in large bold letters because both those sections, paragraphs 22 and 23, talk about trademark type things, business interests, those type of things. It doesn't talk about phone numbers. And I use the phone number analogy because I think that best fits what this person's name.com was and is. And we'll get into the property arguments down the road, but in order for there to have been the trustee has the burden to overcome the notion that you can amend pleadings unless there's bad faith. Bad faith would have to indicate that the debtors knew that this phone number was property. We, at this point, don't believe it is property, nor will it be determined to be property under Washington law or Virginia law, which is actually where the contract existed that gave the debtors any ability to use this phone number. Just like their AT&T bill. They've got a phone number with that AT&T. We didn't identify that because we didn't think we needed to. We don't have a situation where the value has any bearing on it, because all that was in existence, and it's put in more detail in the property arguments, but all that was in existence that the debtor had was a contractual interest with VeriSign. They didn't have anything else, and that contractual interest was good for a year. There has been no actual prejudice to anybody by this not being included. And I state that because the trustee, if they had known about this contractual interest in 2012, would not have had a bidder. Arizona Heidi wasn't interested until 2014 when she changed her name. It was not something that was on anybody's radar because it was simply a one-year contractual interest. Yes, the debtors did choose, after discharge and after the bankruptcy estate was closed, to continue to pay the fee to keep the domain name. But those are all things that occurred after the bankruptcy, and this particular interest was not property at the time. The notice issue, I didn't get any replies, so I didn't have that. I haven't briefed that, Your Honor. Of course, we will give notice if anybody has any comment on it, but I don't believe that they would, considering that we had the settlement agreement and everything else out there for comment, and nobody's commented. But there is no bad faith shown by the debtors if it turns out that the trustee actually has any ability to administer this contractual right that existed in 2012 that has long since expired and receives any funds. The debtors should be allowed to file this exemption.
Sure, it more relates to the other aspect of the motion than this objection to exemption, but there's never been, the debtors have continuously kept up the domain name registration, though, correct? There's not been a gap post-closing of the old case.
I have not explored that, Your Honor, but I don't believe there's a gap.
I don't have anything in the record, though, that tells
I don't think you have anything in the
gap.
record that says one or the other.
Okay. May I respond?
Go ahead.
I would just add, of course, that if one looks at Schedule G and the original documents that were filed with court, to the extent that the other side's arguing that it's simply a contractual right, that was not listed on Schedule G as well, so that was another deficiency in their approach. And to the extent, obviously, that if there's some need for me at that time to renew it as part of my process to attempt to assign or sell the interest in that contractual right, if indeed that's what it was, then obviously I was not able to do that because I did not know about it, and so it seems to me that they're stopped from making that argument.
Let me ask you a question more out of ignorance than anything else, because I really haven't had the noticing issue that you raised. I did just read the rule, and it's somewhat vague, as it always is when the code or rules refers to parties in interest. Well, who are a party affected? Who is that? Is it a case-by-case determination? Wouldn't any creditor potentially object to exemptions if they thought they were inappropriate, even though it's typically left to the trustee? What do most people do when they amend their C schedule? Do they notice the matrix or not?
My impression is that when I see that that's not done, and I've always in the
Thought
back of
that
my,
that should be done.
in the back of my mind wondered, is this a case where I want to object to it? And typically it's not something I'm going to fight over, but that's always been my approach and what I think about when I see it. I don't generally see the other attorneys doing it. On occasion, I think I've seen it once or twice.
Well, I think I can address that. I'm not going to make any grand pronouncements about what I expect to see in every case or anything. All right, the trustee essentially argues that the debtor should be precluded from exempting any interest in HeidiPowell.com because they failed to list it in their 2012 schedules and failed to disclose it in subsequent years. Quote, prior to being abrogated by Law v. Siegel, the law within the Ninth Circuit gave a bankruptcy court the authority to deny an amended exemption claim if the trustee or another party in interest timely objected and showed by a preponderance of the evidence that the debtor had acted in bad faith or that the creditors had been prejudiced, close quote. See Arnold v. Gill, In re Arnold 252 BR 778 784, Ninth Circuit Bankruptcy Appellate Panel 2000. However, Law v. Siegel, this is all one quote, however, Law v. Siegel has abrogated my authority to deny exemptions or amendments to exemptions based on the debtor's bad faith, close quote. Elliott v. Weil, In re Elliott 523 BR 188 193, Bankruptcy Appellate Panel, Ninth Circuit 2014. I'm not sure. I think one could read Law v. Siegel narrowly and just say it only related to the Latimer, Burdett versus Latimer kind of decision that you can't surcharge the exemptions for bad acts by the debtor, but I think that the BAP is correct in determining it just throws out any objection to exemptions based on bad faith. And I'm not determining there's bad faith here. I'm saying I don't need to determine bad faith because bad faith is no longer, after Law v. Siegel, of itself a grounds for denying an amendment to exemptions. Now, state law, if we were dealing with, this was the wild card, wasn't it?
It was, Your Honor.
Asking for federal wild card. So I don't think there's any gloss here that helps. A state law could have some angle that would allow good faith to come back in if, as a matter of state law, good faith was relevant to allowance of exemptions or not. Therefore, regardless of the alleged bad faith, which again, I'm not defining bad faith, I'm just saying it's irrelevant to the equation after Law v. Siegel, I will allow the debtor's exemption the domain name as set forth in their amended schedules, Schedule C, with the following caveat: I'm only allowing it on an interim basis pending passage of 30 days time from a full matrix mailing of the notice of amendment, basically attaching Exhibit C. I don't want to get into what I think is a sort of vague area of me determining that no creditor, because every creditor is potentially affected, but as a practical matter, would they have ever responded to the exemption?
In an additional pragmatic issue, Your Honor, are we okay if we use those addresses that we had in 2012? Or is there some responsibility for the debtor to figure out if those interests have shifted? Because and I will acknowledge to the court and to Mr. Broom, we normally do not do any kind of a notice. But when we do that,
my guess was that was not the common practice.
It is not, Your Honor.
But that doesn't make it right either. So
no, I understand. But I just want to make sure that now if I'm going to do it, I do it correctly, because we do have almost 5 years that have elapsed, and I guarantee, or I can't guarantee because I don't know, it's unclear whether we're, and I want to know.
I think a debtor would normally have a duty to update the schedules with corrected addresses if they knew they were wrong when they filed them. I'm not aware of any duty to update the matrix afterwards. However, if the debtors are, from just a due process standpoint, if the debtors are aware that addresses have changed, as opposed to an affirmative duty to go out and figure it out.
Thank you, Your Honor. I just want to make sure that so we do it correctly. Yes.
All right.
Can I ask a question?
So the order allowing the exemptions has to use the word interim basis because it is subject to further objection for 30 days following notice of that. I guess it could be also subject to, just for clarification, submission of an ex parte order finally allowing the exemption if after that time expires without any objection being filed by any party. Because otherwise, because this isn't something that's a creature of the rules, I'm making it up for this order, I think you're going to have sort of a vagueness in the record as to whether the exemption's been allowed or not after that time period's run, unless you submit a subsequent order. Yes, Mr. Berman.
You had said, as I understood you, that Siegel had abrogated the prior case in regard to bad faith, but I understood you to say that there was also another component in regard to prejudice. So are you essentially saying you're finding no prejudice as well?
No, I didn't say anything about prejudice.
Well, I know you didn't, but
I don't think we get to that argument.
To the extent...
I'm saying bad faith, unless it's a matter of state exemption law, which is irrelevant here because it was the federal exemptions, bad faith is no longer a basis for denying exemption.
But I understood you to say that prior to Siegel, that an attempt to do an amended exemption could be not agreed to by the court for one of two reasons, either acting in bad faith or if there was prejudice. So it sounded to me like the one component of that prior ruling is no longer there, but the other possibility of denying an amendment is still there prejudiced, and so...
Oh, I see what you're saying. Well, that was all from that quote from Elliot, but I don't think I took specific argument on prejudice as a grounds for denying the motion to amend. I think that might still be in play, actually. I guess I wasn't intending to rule on prejudice, because I'm not sure I read your pleading as a separate issue raising prejudice as opposed to bad faith.
Well, to the extent...
Because prejudice would normally be you relied on the lack of, in this case, taking the exemption. It would apply to anything in the schedules, but the lack of, basically the trustee was trapped into doing something different because of the omission of that from the schedules, and the change of the schedules created prejudice, not just inconvenience, not just cost, but actual prejudice. In general, the Ninth Circuit law, as you're quite aware, is quite liberal about amendment of exemptions. So,
well, just to be clear, just to the extent that as part of all the different issues and the arguments that have been made in this case, the debtors have indicated at one point in time that what's in front of the court isn't actually the same contractual right. If indeed it is that, it's something that has been renewed by them since the time of the filing, and to the extent that I didn't know about it and I didn't have a chance to renew it myself, that would be prejudice if they're pursuing that argument still.
yeah, there's such a chicken and egg problem with that logic, because I have spotted Mr. Lester the fact that even though he's claiming it's not property of the estate and you can only take exemptions in property of the estate, that he's got sort of a quitclaim exemption on his hands. Is to the extent it is property of the estate, it's exempt. We have that conceptual...
I'm straddling both camps, Your Honor, because I'm trying to make sure that we... Yes.
I think that if you have an issue with prejudice that you could articulate by the time we're done with all of this, that isn't swallowed up by Law v. Siegel, move for reconsideration.
All right, fair enough. I just wanted to put it on the record.
Okay. All right, let's move on to the other issues. Again, it helps that the amount at least on the table is a higher amount now than it was previously, but that doesn't make the issues involved in this case any simpler. So let's move on to the rest of the proposal to sell. And again, it's your motion, Mr. Brown.
All right. Well, obviously we have the
motion.
The bankruptcy code basically taking a very broad approach that just about anything is an asset and should be scheduled. We also have, as indicated in the memorandum that I filed, that Washington law appears to be the same way, in that property is treated very broadly. We have a number of cases that were in the memorandum that, and your court has also indicated at the very beginning that there's a conflict, different rulings by different courts across the country, but several courts have held that domain name is property, and you have several courts that have basically talked about allowing and authorizing a trustee to sell a domain name. So obviously some courts feel it must be a property interest or an asset of the bankruptcy case. So when you look at the bankruptcy law in general and Washington law in general, they both seem to indicate that it would be deemed to be an asset. We have a situation here where, from my point of view, the debtors have no connection to Virginia. They've lived in Washington. They purchased the domain name while they were living in Washington. They've used the domain name while they've been living here. They filed the bankruptcy in Washington. It seems that Washington has the closest relationship, and as I said, Virginia doesn't really have much of any relationship to them. From my point of view, when I didn't have the chance to look into this because the idea just popped into my head. It seems, at least I would throw out, it seems to me that when we look to Washington's law to define what a property interest is, I'm not sure that we then, as indicated by counsel, we also have to look at some choice of law or conflict of law issues that flow from that state. I would suggest that basically we look to what the state says in regard to property rights, and that's it. We don't go any further as what counsel will ask us to do. In this situation, we have GoDaddy was the registrar that defendants registered their domain name with. It's a Delaware company that operates in Arizona, so that by itself would indicate nothing to do with Virginia, as they would like you to look at. The registry, VeriSign Inc., is a Delaware corporation that currently operates in Virginia, but its headquarters was in California until they moved the headquarters to Virginia in late 2011. It seems to me that Your Honor's decision shouldn't depend on where the registry is at any given time, meaning that the decision would be different if in the meantime they've moved or relocated. Furthermore, VeriSign is the only, as I understand it, is the only domain name registry for .com domain names. So it seems to me that their essential argument is that Virginia law would apply everywhere in the country because only .com can go through them. Also, the way I look at it, there's nothing magical about Virginia. VeriSign's data is not just stored in Virginia, it's stored in data centers all over the country and I think all over the world. So I don't think there's anything magical about Virginia at all. The way I see it, it would mean from their argument that basically if you had Amazon.com or Microsoft.com being .coms, that they would not be valuable property either, and I think that would just be a ludicrous result. So for all those reasons, plus everything else I've said in the briefing, I would say that you should, it is an asset, the sale should be allowed and you should go with the $20,000 offer.
Mr. Lester?
Your Honor, the cases that the trustee put before the court suggest some type of an in rem nature for this interest, and that's what I believe the briefing focuses upon. We've entered this brave new world where we've got these things that reside on computers or servers or move about the country based upon people's choices. The case law is pretty clear, at least from our perspective, that unless there's some trademark or some other intellectual property that has been uniquely created to change this from a phone number, it's not property. And that's the logic that the Virginia court comes in, and we believe the Virginia court is the best place to look for guidance because, as the trustee indicated, the only information we have here is that the situs for the contract that gave the debtor anything in 2012 was Virginia. That's it. That's where they were. I don't know, I didn't see anything in the pleadings to suggest that there's been some movement or there could possibly be storage other places. I don't see anything like that in the pleadings. We didn't get a reply to our response. It wasn't a whole lot of time, but we didn't get any reply.
Let me make sure I understand your choice of law argument, though. You're arguing that, I won't get into too much detail at the moment, but the connection with Virginia is the GoDaddy VeriSign agreement, and that the registrar then is in, the registry is in Virginia because that is the principal place of business of the registry, or because the choice of law in that agreement that the debtor's not a party to is Virginia?
I would argue both reasons, Your Honor, that both support the argument. but I think it's more important that the administration, at least my understanding of the way this works, and I am not an expert in the way domain names are administered, all the information that I've been able to glean from the pleadings, from my discussions with folks that know a whole lot more about this than I do, is that Virginia is where things are administered and controlled. It's where the domain name has its life, whatever that life may be. That's what creates it as something. But for what occurs in Virginia, it is nothing. Consequently, when you're looking at who, and that's why we're in this really interesting, and I hate being in interesting cases, but we're in this whole interesting area of the law, is who has the jurisdiction. I mean, is this strictly an in-rem type proceeding? And so we have to look at which state has control of the administration of this interest, this thing, or can we just willy-nilly go any place and look to any law? Because, yeah, the domain name may end up residing on a computer for a little bit because it's used for something. You know, somebody sends an email. It's there. I didn't brief that issue, and I don't know that there's been any determination on that issue. The whole law on this is in a flux. And court's always much better at finding cases than we are, but we couldn't find any real clean direction in Washington on this issue. We looked carefully at the cases that the court had suggested at their previous hearings. I got help putting this brief together. I believe that they are right on point, that Virginia should dictate what happens with whatever this thing is, because in 2012 and now in 2016, it was Virginia that was doing it. And when we look to Virginia, they've diced through the arguments about, is this just a contract interest or is it property? And it appears...
Let me stop you there for a moment,
Gotcha.
Because that confused me a little bit. Is contract interests are a property, right? I mean, you're not arguing that under 541 a contract interest isn't property of the estate, are you?
I'm not arguing it's not property of the estate. The question becomes what that contract interest was. Was it just that unique 1 year?
Okay, so, and you didn't find any case that said, I think you made the assertion in your pleadings, but you didn't back it with any case saying that if you have, let's say, a renewable yearly contract of some kind, and let's make the facts a little starker, if you had an undisclosed renewable contract in bankruptcy that for whatever reason happened to be very valuable, whether the bankruptcy code treats that undisclosed asset years later as still an asset of the estate because the case was closed without it being disclosed and therefore it didn't automatically get abandoned, does that turn on whether a renewable contract, renewable at the desire of the debtor, ceases to be property of the estate at the renewal date?
I did not address any cases on that, and to be honest with the court, I didn't look at it. I looked at that situation as an executory contract, and the rules within the code that deal with executory contracts were what should dictate what occurs in that situation. But of course, since the trustee didn't know about this, they wouldn't have had the opportunity, as Mr. Berman was indicating, to renew that executory contract. I went and looked at the property code section to figure out what was property. Because it talks about offsprings or profits or rents. That doesn't fit in this situation. But I'll be honest with the court, I have not looked carefully to figure out whether there's been any decisions upon whether a single year lease that it was up to the discretion of the debtor to renew.
But the debtor had a right to renew. It wasn't a renegotiation every year that the other side could back out of.
As long as they met all of the terms and conditions. They could be denied, if they didn't meet the terms and conditions in the contract.
Right, but you don't have a case that says whether that undisclosed asset years later is property of the state or not.
I do not. One way or the other, Your Honor, I do not.
All right. All right, anything else you want to add? I'm not going to rule from the bench on this, but I want to get all the arguments on the table. And I will, do you have any clear cutoff on the offer? This is complicated. I'm not going to write a law review article type opinion on it. In fact, I'm probably not going to write anything. I'm going to give an oral decision on this. I will try to keep it as limited to the issues as I need to determine to make the ruling, but there is an interplay of a handful of things, most of which are not very set in stone out in the case law. So it's going to take me a little bit of time. And do you have any clear idea when it's moot?
My understanding is that the money that's being offered is sitting in the trust account of the attorneys down in Arizona, and they're willing to wait as long as possible.
All right. Well, I hopefully am not going to wait as long as possible. I will get to it as quick as I can, but it's going to take a little bit of time. So as with most of, well, go ahead, Ms. Lester.
Your Honor, are there any issues that you need additional clarification from us?
Well, if you had a case for me on the issue I just raised, I would take supplemental briefing on it.
Okay.
Because I don't even know if there is such case law, I'm not going to require supplemental briefing. I would say you're certainly safe within the next week in getting any supplemental briefing in that you wish to get in. I will tell you, frankly, where I'm leaning right now, if it helps in your settlement discussions, but having ruled on the exemptions, I'm not sure there's much on the table for settlement other than my yes or no decision on this. Is I'm leaning toward thinking that, just like the Utah judge did in that case involving freecreditscore.com, that 541 is very expansive, and even if the property interest involved is merely the right to enter into renewals of that contract, whatever you call that asset is still an asset of the estate. I'm a little bit hung up on the when you're not dealing with a commercial entity, the telephone rule analogy, but I don't think I have any binding law on me, and I think that was sort of a quirky old case-made rule from pre-code days anyway. So whether I would expand that out to cover a domain name, when yes, in some situations it's no more valuable and just as personal as a telephone number, but in other cases it's an extremely valuable, I'll use the word asset. I mean, if it was Microsoft and you were coupling it with a trademark, I think you'd all agree it's an asset. It's the situation where somebody wants to pay money for it, but in fact it isn't tied to a trademark that is the trickier issue here. But my leaning is to lean toward the trustee and say that it's an asset of the estate. He can sell it. I don't think there's other procedural problems with his request to sell it, even if it started life out as a settlement motion. And I don't even think you're arguing that at this point. There's not really a due process argument on the table, I think. But I need to look at a few things. That's a provisional indicator of where I'm heading, but I will render a ruling on it. I think I will do it orally, and I will have my chamber staff get a hold of both of you, and we'll pick a time for a telephone conference call for me to announce my ruling once it's ready.
Right, this is more of the other side's issue, but I would assume that to the extent that it's a possibility that Your Honor could say it's not an asset, that to the extent that you talked about them giving notice to creditors of the exemption, that they probably should just hold off on that?
We're going to go ahead and give the notice.
No, I think they should, because I think it's important for them to have that exemption nailed down, even if I rule as I'm leaning totally your way.
Okay.
Right.
And it sounds like the court prefers that process, and so we'll start doing it.
Yes, it's part of my other ruling. It's independent of what I will eventually rule on this asset.
Okay.
I mean, if they had an utter confidence that they were going to win, they may not want to spend the money, but
I would just indicate, I don't know if the court perceives it as that I'm not a maverick in regard to the domain name issue. If you happen to go to any of Trustee Klein's meetings of creditors for years now, as part of his opening remarks, he explicitly mentions domain names every time.
the academician in me would love to give some persuasive authority out there analyzing the choice of law issues and all of the things that you guys have raised. The practical attorney in me wants to just issue a simple ruling once I have determined what I'm going to determine. I think the practical attorney in me is going to win out in this case. I will announce to you both when I'm ready to roll. All right, thank you. And I believe that was the last matter on the calendar. Is anybody here on a 10 o'clock matter thinking? Please come forward. Do you have paperwork with you?
No, I had court scheduled and I looked out on there and it said courtroom 2. And
Wait, for a bankruptcy matter?
no.
Oh, yeah, no, I'm a bankruptcy judge, so it's not in front of me, whatever it is. All right. Good luck. We'll be at recess, thank you.
All right.
You can say, take care. I didn't figure that kid was.
You picked the wrong courtroom.